4 minutes.
The gentleman from Tennessee is recognized for 4 minutes.
Thank you, Mr. Chairman. I appreciate your yielding. As some of my colleagues said so eloquently during last week's judiciary markup on this bill, that the majority's attempts to turn routine exercises of presidential discretion into constitutional violations is nothing but a show and a pretext to attack the President of the United States. The hearing we had reminded me of a Woody Allen saying in a movie called Bananas. Acting as Fielding Mellish, he said, "This is a travesty of a mockery, of a sham of a mockery, of a travesty of two mockeries, of a sham." That's what this bill is, that's what that hearing was, and that's what this proceeding is. H.R. 4138 would establish a process by which one House of Congress could sue the President when it determines the President failed to faithfully execute a law. One House, not two houses. They talk about the separation of powers. Separation of powers is executive and legislative is Senate and House. Now, the House originates spending bills and the Senate confirms judges and things like that. And there was some discussion yesterday, and the chairman brought up a situation where the Senate went to the court on an issue concerning some appointments, which the Senate had exclusive jurisdiction on. But it's when they had exclusive jurisdiction. In situations where there's a bill passed and the Senate and the House co-share equally, unless the Senate and the House both want to act, it's not separation of powers. It's one House trying to act as a star chamber to take down the President of the United States. This bill would, if enacted, represent a massive upending of the carefully calibrated separation of powers of our Constitution. One House, not the two houses of Congress acting. And one of the gentlemen in trying to defend this law and Rules Committee talked about something in Florida. Well, Florida, whatever they've got some kind of situation, but that was a quo warranto action where the governor was acting beyond his authority, ultra vires. It wasn't where the President is acting within his authority and his discretion and determining what is the best way to act. Difference between taking action and not taking action, and taking action you're authorized not to take, and taking action you're not authorized to take. They didn't defend their position once correctly. Congress lacks the standing to sue, and Mr. Conyers has brought that up. Standing requirements are necessary. And also, by drafting federal courts into deciding what are essentially political questions, the bill further upsets that separation of powers. Questions about when and how to implement and enforce laws are within the President's discretion, as the Take Care Clause makes clear. It is the President's duty alone to take care that the laws be faithfully executed, not the courts and not Congress's. The courts rightly avoid involving themselves in disputes between the branches on questions of how a law is executed. This bill flies in the face of such. Ultimately, though, this bill and the larger debate surrounding it have nothing to do with the finer points of constitutional law. That's a red herring. It's a part of a broader attempt by Republicans to delegitimize anything that this President, Barack Obama, does. Here, the majority complains, among other things, about the fact the President delayed implementation of certain provisions of the Affordable Care Act, like the employer mandates for medium and large businesses. You know, the Rolling Stones had a song, "Sometimes you get what you want, sometimes you get what you need." With the Affordable Care Act, they got what they wanted and what the President thought the country needed. And now they're against it, holding the President up to ridicule and claiming it's the process, even though they're in agreement with the substance. In Yiddish, that's called chutzpah. In law, it's called estoppel. And in Congress, it's called not being able to take yes for an answer. I find it odd that this is what they choose to emphasize, that this President is acting in an allegedly unconstitutional way to undermine his own signature legislation. It shows the depths of what Beck referred to as Obama derangement syndrome, where the President's opponents are so determined to thwart him, they will say anything, including reversing their own long-held views, if they believe so doing will weaken his stature. This is unfortunate because President Obama has led where this Republican House has failed. On immigration reform, on financial reform, on environmental protection, on the minimum wage, and yes, on health care. The thanks President Obama gets from this majority for his efforts to implement and enforce the laws as thoughtful as he could is to be accused of violating the Constitution. I yield back the balance of my time.
The gentleman's time has expired.
Thank you, sir.
The gentleman from Virginia.
Mr. Chairman, at this time it's my pleasure to yield